Hello, everyone, and welcome to the Political Forum. Tonight's event is a panelist forum on defamation, free speech, and the future of Me Too, based on the Johnny Depp versus Amber Heard trial. Now, at first glance, when you look at this event title, you might think this has like almost like a tabloid type of gossipy element to it, something that you would see on TMZ, but this case actually has quite a bit of public policy significance as it relates to things like free speech, defamation, and Me Too, as well as certain domestic violence components that we have in our legal system. So here is the event description from our meetup page. In light of the recent jury verdict in the Johnny Depp versus Amber Heard defamation trial, we will discuss the outcome of the case, as well as the potential free speech consequences and the future of Me Too. We're delighted to announce a panel of esteemed legal experts, including distinguished professors and attorneys, in providing their legal analysis. We will then follow up with a Q&A from the audience. And here are some of the points that will be raised and discussed with the panelists. The defamation jurisprudence and how it places limits on both the freedom of speech and free press. Next, the legal standard for a plaintiff to prevail in a defamation case, how the law distinguishes private versus public individuals and the rationale for that justification. Next, the digital age, how does the publication or communication, and those two terms are cited with air quotes because it's a term of art, how do those publication and communication element of defamation apply for the speaker or the platform provider? In this case, we're referring to Washington Post in terms of how they publish the statements. The next question is, was Amber Heard's assertions of the right to speak freely and openly persuasive, at least according to the jurors? How will the outcome of this case have a chilling effect on free speech, if any at all? Next, how will the outcome of this case be a setback or backlash to #MeToo, if any at all? The next question is, how should our public policies protect the victims of domestic violence and sexual assaults? We will then look at the UK case that took place previously, which is Johnny Depp versus News Group Newspapers Limited, which is the Sun newspaper. How was that case different than the case that took place in the state of Virginia? And then finally, if we have time, we will look at the outcome of the jury verdict. Did you agree with it or did you not? And how does your support or opposition to the jury verdict conform to the partisan divide that's as we're in the midst of society's ongoing culture war? So those are some of the questions we will try to explore tonight. And let me introduce you to our panelists in alphabetical order. First, we have Professor Roy Gutterman, who is an associate professor of communications, law, and journalism, as well as the director of the Tully Center for Free Speech at Newhouse School in Syracuse University. He was a reporter for the Cleveland Plain Dealer and also a former practicing lawyer. Welcome, Professor. And also, I will put a link. He has an article that's been posted, which is entitled Depp versus Heard Portends More Defamation Lawsuits and Less Free Speech. It's an opinion piece that I will send a link for you to check out. Next, we have Neama Rahmani, who graduated from UCLA at the age of 19 and Harvard Law School at the age of 22, making him one of the youngest graduates in the 200-year history of the law school. Upon graduation, Neama was hired at one of the largest firms in Los Angeles, O'Melveny and Myers, where he represented companies such as Disney, Marriott, and the Roman Catholic Church. Neama wanted to help the ordinary people, however, and not corporations. So he joined the U.S. Attorney's Office, where he prosecuted drug and human trafficking cases along the U.S.-Mexico border. While working as a federal prosecutor, Neama captured and successfully prosecuted a fugitive murderer and drug kingpin who had terrorized Southern California and was featured on the show America's Most Wanted. He has an extensive trial experience. He has led teams of more than 170 attorneys in litigation against the largest companies in the world. He has successfully tried dozens of cases to verdict as a lead trial counsel and has argued and won before both the state and federal appeals courts. Over his career, he has handled thousands of cases, containing many 7- and 8-figure settlements and judgments. And he has helped his clients win more than $1 billion. He's a regular legal commentator on various news and television outlets, and he sits on the UCLA Political Science Board of Advisors. He lives in Los Angeles with his wife, who's also an attorney, as well as his son and daughter. Welcome.
Thank you.
Okay. Last but not least, we have Professor Christine Scartz, who is a clinical associate professor at the University of Georgia School of Law. She's also a director of the law school's Jane W. Wilson Family Justice Clinic. The clinic provides free representation to low to no income victims of domestic violence. And she teaches family law and a course for undergraduates entitled Law and Social Justice, Strategic Advocacy. She has served on the executive board and fatality review of the Western Judicial Circuit Domestic Violence Task Force, and currently chairs the Firearms Surrender Protocol Committee of the task force. Professor Scartz joined the law school's faculty in August of 2015, and prior to that, she was an associate attorney in a private firm in Lawrenceville, Georgia, where she handled domestic violence and criminal law practice. She has also served as an appointed attorney for criminal appeals in the Gwinnett County Superior Court. Professor Scartz earned her bachelor's with distinction at the University of Virginia, and then she obtained her law degree, magna cum laude, from the University of Georgia School of Law, where she was inducted into the Order of Coif and received the William K. Meadow Award for Outstanding Public Interest Law. Welcome, Professor.
Glad to be here.
Okay, well, thanks for joining us. So why don't we open it up to our panelists? And there's a lot that happened over this, I think it was a 5-week trial. So we would like to get your initial reactions to the jury verdict. And why don't we start off with one of our panelists. Feel free to chime in. Who would like to go first? Anyone? And while we figure out who's going to go first, what we'll do is each panelist will spend a few minutes, maybe 5 to 10 minutes or so, sharing their initial reactions, and then after that, we'll just have a panelist discussion back and forth. That's the first half of the event, and then for the balance of the event, we will open it up to the audience for Q&A. So if you have any questions, feel free to chime in at that time. So I guess
I can jump in, Thomas.
Sure.
Let's get this started. So this was an extraordinary trial for many reasons. First, it was a tremendous legal comeback for Johnny Depp after losing so bad there in the UK. And we're going to talk about that case. But to come here with less favorable laws here in the United States and not only win, but win overwhelmingly in both the courtroom as well as the court of public opinion. I would say well over 90% of folks in the public and on social media were on Depp's side before the jury verdict. And to get such an extraordinary damages award when his attorneys didn't even argue for damages during closing arguments. This is nothing less than an overwhelming win for Depp and a huge loss for Amber Heard. If you kind of drill down a little bit, and the jurors are starting to speak. We got the first interview with ABC News, an anonymous male juror, and really this case came down to credibility, and they found that Depp was much more credible. Both of them testified multiple times during their case in chief and on rebuttal. Cross-examination lasted multiple days. And you really saw one side, Depp's side, that had a huge advantage in terms of likability and credibility. Obviously, there's many First Amendment implications. We're going to talk about it. But, Amber Heard really lost a case that she could have won. Part of it was her narcissism. Part of her is taking really sort of an extreme position when it came into facts that weren't relevant to the allegations in the case, the abuse, the sexual abuse, the physical abuse. She took positions saying that she donated $7 million to charity. That was the proceeds of her divorce settlement. Well, turns out that wasn't the case. She tried to walk this path and say that she'd pledged that money. Facts related to leaking videos and tipping off TMZ. She claimed not to have done so, even though the video came from her phone. I'm just bringing up examples of how she lost this jury. And when we got that first jury interview today, the jurors specifically said, we thought that this was a mutually abusive relationship. And Amber Heard taken a little bit more of a nuanced position, accepted some responsibility for some of at least the verbal abuse, and not taking this position that, you know, she only used drugs one time and she only hit Depp one time. We may have gotten a different result here, but instead she's sort of doubling down, and now she's taking her chance on appeal. I think the likelihood of that being successful is going to be really slim to none. The arguments are social media, which I'm sure we're going to talk about. The interest in this case on social media was nothing like I've ever seen before. I regularly do court TV and law and crime, and I did daily trial commentary on this case, and the viewership was 20x what it typically is. And I've covered Rittenhouse and the Trump impeachment trial and the George Floyd murders, Ahmaud Arbery, really important cases, but the level of public interest in this case dwarfed all those combined. So you really see an overwhelming public response. And the question is, you know, you have domestic violence, you have sexual assault. These are two of the most underreported crimes. Really, what does this do to victims that are already hesitant to come forward after a verdict like this, Thomas?
Okay, thank you, Mr. Rahmani. Now let's go to, I guess, Professor Scartz.
Sure. I think when you asked the question, what's the reaction to the case, to the verdict, I remember the minute that it came out, I was relieved, and I'll explain why I was relieved that it was not, in essence, a total vindication of one side or the other. I remember being just delighted that there was going to be money going both ways, only because I was very nervous after watching all of the social media attention that came to the case, that it would be a 100% Depp verdict. It just seemed like Mr. Rahmani was saying, it seemed to be going about 90% or more in that direction. I will note that in a lot of the coverage, you saw references to their 2016 divorce and protective order proceedings from several years ago. Ironically, some of the students in my clinic had looked at the original pleadings back when they were filed back in 2016 in an effort to sort of, I guess the idea behind what we were discussing was domestic violence happens to all kinds of people. So at the time we were looking at those original pleadings, there didn't seem to be a question either in the media or even in the minds of my students that Amber Heard was the victim of some pretty severe domestic violence. And so to see how in a course of many years that got left behind and it really became an issue, as was said, of likability, was really kind of stunning to me to see how over time that had changed. And I think when you think about this issue of likability, you know, folks who have not either had domestic violence touch their lives in any direct way, haven't been victims themselves, they didn't like Amber Heard because they look at this beautiful, wealthy person and say, well, whatever was going on in her life, it couldn't happen to me. So we have to distance ourselves from her in that particular way. Then what I had seen and heard was that victims of domestic violence, survivors of domestic violence, didn't like her either, because she was dragging all of them down. She was bringing everybody's credibility into question. So it just that change over the course of years of looking at this relationship was really kind of shocking to me. So my work is with, as you mentioned, low and no income folks. So it was interesting to me to hear throughout the testimony of both parties similar threads to the things we hear amongst regular folks day in and day out. And I think as we do get to hear more and more jurors' opinions, we'll have a little bit clearer picture of how this case is going to impact the cases of regular people, not defamation cases, but actually cases adjudicating whether domestic violence has occurred or not as the main issue, see how that impact is going to be going forward.
Okay, thank you, Professor Scartz, and let's go to Professor Gutterman.
Thanks for having me. I was part of that 20 times the normal size audience on Court TV this summer. And this was a gripping courtroom drama involving celebrities. And whenever you have that kind of entertainment value to a serious matter of litigation, it's gonna attract the social media memes, the people in costume outside the courthouse, people lining up at the night before to get a coveted seat. So it turned into, as I wrote in my piece, a little bit of a circus. And whenever you have a circus of that magnitude, it seems the last thing on anybody's agenda is the actual truth of what happened. And in many ways, this gripping courtroom drama with high-profile celebrities and gossipy type stuff and other celebrity witnesses, it was exactly the kind of distraction many people needed at the beginning of the summer when we're looking at all the political, economic, and world turmoil that surrounds us. So in many ways, this was a distraction for many people, especially the people that were lining up outside the courthouse to get in. But with all the entertainment value, and I don't mean to minimize the impact of what was really at stake, because let's go back to the 2018 column that was published under Amber Heard's byline. The full extent of her contributions to that piece were negligible, perhaps, based on the testimony. But this was an editorial, a personal editorial, a column that broached some pretty serious issues. The issue of domestic violence. She declared herself a survivor or victim, whatever nomenclature you want to apply, of domestic violence. And somehow Johnny Depp read into that this was somehow an attack on him and on his reputation. So he brought this defamation lawsuit. So before we get into the details on that, let's take one step back to what was really litigated here. This was a civil matter. Nobody's going to jail. And it was about truth or falsity of a published piece and whether that publication caused harm to this quirky celebrity's reputation. And at the end of the day, he got about $10 million, and we can get into damages later. But the heart of this story, if we want to call it a story, is the truth or falsity of these allegations and these statements that were made in an opinion piece that didn't even name the plaintiff here. So there's some quirky elements to the actual litigation as well. And I'd be remiss to note that the contentious litigation between these two parties seriously outlasted the marriage itself. So that might tell you a little more about what this was all about as well.
Okay, thank you, Professor Gutterman. And before we engage further into this topic, I'll just read an excerpt from this op-ed piece that was published in 2018. And I believe this statement here is really what's at the heart of this case, which is, quote, 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And as Professor Gutterman had pointed out, she does not mention her former spouse, Johnny Depp, but obviously being a public figure, anyone reading this piece would know that that's who she was referring to. So before we get into the nuts and bolts of what happened in this case, I just want to ask some basic questions because perhaps some of us here may not have followed the case closely. The case took place out of Fairfax County Superior Court. And if someone can explain how come these Hollywood celebrities are in Virginia courts, that's the first question. And then the second question is, wait a second, I thought there was another case in the UK. How is that different than what happened in the US courts? So any one of those two questions, classic Civ Pro question that you would see at a first-year law school.
Yeah, I can take this. So I'm sitting here in downtown Los Angeles, a few blocks from where Johnny Depp and Amber Heard lived. And, California and Los Angeles in particular is very First Amendment friendly. We have anti-SLAPP laws, which are strategic lawsuits against public policy. With the right judge here in Los Angeles, there's a good chance that this case never would have even made it to a jury. The other possibility was New York, of course, where the ACLU is, but really Depp's lawyers desperately tried to get this case, and they're successful in doing so, in getting this in Northern Virginia, where the Washington Post is headquarters and where their servers are. Certainly not a red jurisdiction by any stretch in terms of the jury pool, a little more purple, but still a lot better than the other possible venues that Depp's lawyers could have filed in.
Okay, and then the second part of the question was, how come the case was already litigated in the UK? How were they able to have a separate lawsuit in the US?
The UK case involved a tabloid newspaper in the UK that basically called Johnny Depp a wife beater. And the law in the UK is ironically more plaintiff friendly. The burden of proof rests on the defense to prove that it's true, rather than the way it is in the US that requires the plaintiff to prove that it's false. So that verdict, which was before only a judge, it was a bench verdict, no jury. So under a more difficult standard of proof before a judge, Johnny Depp lost. And many observers who know this area of defamation pretty well look to that as some sort of probative value or proof that in the United States, where it's way more difficult for a plaintiff, much less a public figure plaintiff, to win a defamation case, that seemed to be an uphill battle for Johnny Depp, which he obviously was able to scale and win.
Okay, and there was also a counterclaim component to this case where Amber Heard asserted that somebody on behalf of Johnny Depp had made a defamatory statement, and I believe that statement came from Depp's matrimonial attorney, Adam Waldman, back in, I guess, 2016. So how can a defamatory statement made by another person attach to Johnny Depp? Does anyone know that answer? No?
Yeah.
Yeah.
Well, yeah, I can take this one too. So yeah, there's the 2016 incident where someone from New York called LAPD, and Adam Waldman, who was Depp's divorce lawyer at the time, said that Amber Heard was perpetuating a hoax. Well, it turns out that Heard didn't make the phone call. And when LAPD showed up to their penthouse, she didn't even cooperate with them. So I think that's sort of what the jury hung its hat on in terms of finding that that statement was defamatory. As far as why Depp was responsible for it, that although for the law professors, but we learned about principal agent liability, and obviously the principal is liable for the acts of the agent. So that's why Depp was liable for those statements, even though those were made by Waldman.
Okay, so Mr. Rahmani, I want to go back to a comment that you had made earlier during your intro, where this was quite a comeback, a legal comeback for Johnny Depp, and he was found to be more likable. But I think the argument that was made by Team Heard is that, look, Johnny Depp is your classic powerful man in Hollywood with millions of followers on social media. He's very well resourced. So again, this is yet another illustration of how in this context, again, the aggressor versus the victim is always the less advantage. So how would you explain that dichotomy?
Yeah, I mean, there's no question. I mean, and this started really with former President Trump using defamation law to go after his political adversaries, right? Now you have Johnny Depp, who's really set the roadmap. And let's not forget who's usually accused of sexual assault. I mean, oftentimes it's rich and powerful men, right? Celebrities, actors, athletes, entertainers. They usually have more money than the accused. Usually they have more money than the accusers. So sometimes the best defense is a good offense. And are we really going to see the beginning of this roadmap where, maybe Cosby's, Weinstein's, other folks, Kevin Spacey's of the world, they go after their accusers, file civilly, be the first to the courthouse, and Obviously, there's no right to a appointed lawyer as a defendant in a civil case. And oftentimes, I don't know if these accusers are going to be able to even afford representation, and much less the ability to litigate this case over years. It's going to cost millions of dollars.
Okay, and Professor Scartz, let me toss that question to you, because for someone who has handled many of these domestic violence cases, can't you see a scenario where now this could have a chilling effect where the accuser might have some concerns about potential legal backlash down the road?
Well, sure. The accusers are in many cases and very brave to come forward and disclose the things that they allege are happening in their home. And they feel that once they make those allegations and statements that they ought to be believed, and it's almost a surprise and a shock to them sometimes when they are not believed. They don't expect to be challenged on their truth. So now many accusers will hesitate to go forward just on the slim chance that they could be then called liars or fabricators, because quite honestly, in a lot of abusive relationships, there is a lot of gaslighting that goes on. Even where a perpetrator is committing abuse, pretty much the first thing they say is, I didn't do that. You misunderstood that. That didn't happen. And so accusers are already in many cases doubting themselves before they come forward in a public forum. Nobody wants to be called a liar, and many people will stand down if that is a possibility. But I will also say that the reality for most folks is that they are not going to get sued for defamation, because no lawyer is going to take a case against them because there's no money in it. If there is an explosion of pro se and unrepresented litigants doing defamation cases, holy smokes, that is going to change things. But the reality for most folks is it is the mere threat of that sort of suit rather than actually, I mean, if you're risk preferring, go ahead, sue me, right? I don't have anything, come get it, So, but most people aren't going to have that sort of very, very, I guess, self-assertive attitude in that way.
And when we look at domestic violence cases, typically, at least from what I've seen, it's the men who are the aggressors and women who are the victims. In this case, it seemed like they were trying to make an argument that there's kind of like a mutual abuse going on from both sides. How much do you think that is prevalent? So the term perfect victim has been tossed around a lot throughout these past couple of weeks. And we do often indeed tell our own clients, you don't have to sit and take it to get relief from the court. You don't have to never have responded or indeed perhaps even initiated an abusive incident in order to receive relief from the court. That's sort of a very old 70s, 60s idea of what a victim is, who a victim is. But I do have a little trouble with the term mutual violence, and it plays into the same sort of ideas of relative power that we're talking about as far as finances and popularity. And when there is a power dynamic, that means to me and many advocates that the acts of possibly physical violence that are named, sorry about the dog, as being she slapped him, he hit her. Well, when there's a power differential, it doesn't mean the same thing. So I in some respects take a little exception to the term mutual violence. Just because I can have been said to have hit or scratched someone doesn't equalize being strangled or punched by someone much larger and perhaps who has other emotional or financial power over me as well. And for those of you who followed this case closely, I think Johnny Depp's defense was that there was no physical violence directed at Amber Heard. However, there's audio recordings of him, smashing the cabinet. yelling and saying all kinds of just really bizarre things. So I guess the question is, to what extent does verbal abuse that's almost tantamount to harassment, should that also get the same kind of protection under the domestic violence laws?
If you're asking me to continue, I will, certainly. So that is actually a really interesting topic because DV laws vary across the country, as I think everyone knows. So in fact, in Georgia, where we are, no acts of verbal abuse that are short of credible threats of immediately receiving a physical harm are even actionable. So in California, for example, I believe that the laws are very much broader in their definition of abuse. It would include financial abuse and what might be generally or loosely termed mental abuse, verbal abuse, emotional abuse, those sorts of things. In Georgia, none of that, right? I mean, so it varies very widely. And do I think that the definition should be broadened? Certainly, but it gets really tricky when then you are talking about moving it into litigation, because it does open up the door for more mutual allegations or allegations from both sides, where perhaps, again, the power dynamic that's inherent in physical threats and physical acts isn't really taken into consideration in that. So it's something that the states are going to decide, I think, individually on how to broaden that definition.
Okay, thanks. Professor Gutterman, here's a question. In the UK case, I believe the characterization of Johnny Depp was he was, quote, a wife beater. And the Sun, the publication, prevailed. So if you're using that logic, Amber Heard could simply say, well, the UK courts found the Sun to be credible by calling him a wife beater. And I just kind of built based on that premise, and I wrote that op-ed piece. So their defense has always been, look, this is all about free speech. Let Amber just exercise her free speech. So where did that exercise of free speech cross into defamation?
Well, the UK judgment was a critical point, and Heard's lawyers tried to incorporate that in some pretrial papers. There were motions to have the Virginia court, in many ways, throw out the case based on this foreign judgment. And anybody who practices law in the United States knows that US courts are extremely loath to incorporate international law, if not outright hostile toward it. So, and it's also interesting when there's this issue in our world called libel tourism, where plaintiffs look for the most hospitable place to sue people for defamation. And a number of states actually have laws that will not enforce a foreign judgment for defamation if the foreign jurisdiction doesn't have anything similar to our judicial standards for defamation. So it's kind of interesting how Heard's lawyers wanted to kind of invert this longstanding principle to point over to the UK and say, hey, look, he already lost over there under a more difficult standard, therefore you should throw it out here. And the judge did not find that to be an availing argument, even though substantively, I think it was a good argument, and that was a theme that was incorporated in much of the pretrial litigation, but it just didn't resonate once we got to the trial. And Team Heard tried to make this an issue about domestic violence and the truth and falsity surrounding that. And Team Depp basically put Team Heard on trial. So there was an interesting turn of the tables with how this trial played out. And by the middle of this thing, it seemed like the truth and falsity elements were almost the last thing that anybody was even talking about, which is a troubling issue when you look at the weight of what was in that column.
Okay, and speaking of different legal standards for defamation, I know there's different standard for a private person as opposed to a public person. And I remember as I was watching this trial closely, they kept on talking about the actual malice. So if you could just kind of tell our audience what that means.
Sure. Actual malice is a term of art. It's perhaps one of the most vexing legal standards and terms out there. The term comes from a 1964 case called Thomas v. Sullivan, in which an Alabama police commissioner sued the New York Times over an advertorial that tangentially mentioned all sorts of abuses perpetrated by government officials during the civil rights era. And Justice Brennan wrote the opinion in this case, this landmark opinion, and he brought in this concept of actual malice, which doesn't mean what it even sounds like. Actual malice means publication with either known falsity or reckless disregard for the truth. And that's a standard that is attached to initially public officials, people in government, and then later through some subsequent precedent, public figures like, say, famous actors or athletes or just famous people. So again, actual malice, many people mistake it and say, well, it means intent. Intent really is not the issue. Intent can be inferred from at least the known falsity prong, but it's not an element that the plaintiff would have to prove. It's not like the other torts like battery or anything like that. So long and the short of it, actual malice means that this false statement was published either knowing it was false or with reckless disregard for the truth. And again, the reckless disregard element here, just think of it as, somebody who was really, 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 really irresponsible, that they published something that was just so irresponsible, it shouldn't have been published. And that's a high burden. Juxtapose that to what a private figure or an ordinary plaintiff has to prove, which is simple negligence. So many defamation cases are won and lost at the preliminary phase, depending on how the plaintiff is situated, whether it's a public or private figure. So there's a lot at stake pre-trial with this.
Okay, thanks. Mr. Rahmani, you have a lot of experience in the courtroom. So as you watched the trial, what were some of the highlights, or what were some of the certain mistakes that were made on both sides in terms of their prosecution of the trial?
Yeah, I think several mistakes were made by Amber Heard's team. And obviously, I tip my hat to Depp and his lawyers, Ben Chu, Camille Vasquez. They've gotten a lot of credit. They won this case. But in many ways, Heard lost this case. And, I talked a bit about her testimony, some issues where she lost credibility, but there were also some exaggerations, I think. I mean, she testified that Depp kicked her so many times she lost count, that she thought Depp was going to kill her. And I don't think the pictures and videos that she showed the jury supported that. And I think that's a place where she lost credibility. But also from a legal strategy perspective, I mean, one of the 3 defamatory statements was sexual violence. And Heard did talk about some very disturbing incidences. The first was the body cavity search in Hicksville, and then the bottle penetration in Australia. But during closing, they really got away from that. They said that verbal abuse is sufficient, and I agree with Christine that it can be sufficient, but really the statement that they needed to defend was sexual violence, and they didn't spend enough time on that. I think they also spent too much time. They wasted time, frankly, during Depp's case in chief, so much so that by the time that Depp's case in chief was over, they had used more time. So you saw them scrambling towards the end. They couldn't get witnesses to testify in person. Depp had more witnesses, more persuasive witnesses. The only in-person witnesses that they really had were Whitney, who's Amber Heard's sister, as well as some paid experts. But the rest of their good witnesses testified via videotape deposition, not as persuasive before the jury. And then also, they just spent too much time on Depp's substance abuse, the drugs and alcohol. They brought witness after witness to talk about it, but really, I don't think that was an issue that was disputed. Depp himself testified that he started using drugs and alcohol at age 11 because of abuse he had suffered at really the hands of his parents, but primarily his mother. And again, just valuable time wasted. Not to mention, some really, Elaine Bredehoff had a tough time during Camille Vasquez's objections. I mean, as someone who's been practicing for 40 years, frankly, I think she did not a really good job on handling the objections from Depp's side. So here's some mistakes I think that were made by both her and her legal team in this case.
Thanks. And in terms of evidence that was introduced during the trial, I know there were quite literally hundreds of documents as part of both sides' exhibits. I think the argument that Team Heard was making was this, that if they have some evidence, whether it's photographic or audio recording, etc., they'll say, well, the veracity of the evidence is criticized because it's not sufficient. Maybe there should be more photographs, there should be more recordings. Or if they don't have any evidence, like for instance, I guess there was some episode that took place in Australia where there was like some kind of alleged violence, episode of violence. There was no, record of Amber Heard going to hospital. So therefore, based on the absence of evidence, that means that incident did not happen. So it's kind of like almost the way how they were, the dilemma that they were in. It's like either damned if you do, damned if you don't. Okay, go ahead.
All right, so you're kind of going back to the juror feedback. So we're getting some insights today. The jurors thought that Amber, frankly, was acting, that those were crocodile tears. She'd be crying 1 minute, she would be stoic the next. And obviously, they're both actors, two very good actors. So, and the stories were so incredibly different. There was really kind of no middle ground here. Sometimes there's a gray area or compromise, but when you heard Depp testify and you heard her testify about the same incident, they could not have been more different. So I think the jurors were stuck in this position where they had to believe one side or another. And because of some of the statements that Heard made, the fact that, for instance, she opened the door to Kate Mott's testifying that incident never happened. And very importantly, let's not forget, she opened the door another way. She testified during her case in chief that she had never been violent or abusive towards her ex. Well, guess what? That opened the door to a Seattle airport officer coming in and saying, no, there was an incident where I saw you, Amber Heard, drunk, violent, abusive, aggressive, pulling a necklace off of your significant other. I think that's where she lost this case, because again, once the jurors found that she wasn't credible, those tears weren't genuine, they were stuck in this position. They shifted towards Johnny Depp.
Okay, sorry about that. Looks like we have an infiltrator here. Just 1 second. Let me just get rid of this person. Okay. So you had talked about crocodile tears and credibility. I mean, at the end of the day, you have both parties who are actors, and I'm sure they can put on an act. So if it's all about their performance or the performative value, are we really judging these characters just based on their performance in the courtroom, like how they would perform at a stage?
Yeah, and I never want to disparage jurors, but sometimes trial lawyers say these are 7 or 12 strangers who can't get out of jury duty. These aren't trained professionals. I mean, they are going to be influenced by the testimony of the witnesses. And look, in a civil case, the witnesses are going to testify. Even in a criminal case, when the defendant takes the stand and testifies, the entire case usually will come down to his or her testimony. So when we knew Depp and Heard testified over the span of days, whoever did better would likely carry the day. And it was clear as time went on that Depp was the better witness. He was more truthful. He accepted some damaging text messages, for instance, with Paul Bettany. He didn't run away from them. He embraced them. He was very vulnerable, talking about the abuse he suffered, why he started using drugs and alcohol. So I think the jurors thought that, look, here's someone who's been honest about these other very embarrassing things that are actually unlawful. So we're going to believe his entire testimony. Okay.
And let me broaden the question, because I know there was a reference to a previous domestic violence matter that took place back in 2009. And can you explain how that evidence got into the trial? Because that sounds like your classic propensity argument that sometimes may or may not be prejudicial for the fact finder.
Well, it didn't come in at first. And this is, again, mistakes that Amber Heard made. You saw Ben Chu famously fist bump, and that was shared a lot on social media because Amber Heard started talking about Kate Moss. Her testimony was excluded until Amber Heard started talking about Kate Moss. So that's why Kate Moss came in and testified that Depp was never abusive. And that staircase incident, she slipped. In fact, he was a gentleman, tried to help her. So again, that's someone that did not have to come in. The judge had excluded it until Amber Heard opened that door. Similarly, that Seattle police officer, jurors love law enforcement. When Amber Heard took the stand and said she'd never been abusive towards an ex, guess what? The judge said, well, look, on rebuttal, I'm now allowing that officer in. So those are some strategic legal mistakes that Amber Heard and her lawyers made.
And if we go back to the previous kind of premise that was mentioned about how you have one side who is very rich and powerful and the other side who is not as rich and powerful. And based on what I'm hearing from Mr. Rahmani, so Johnny Depp brought in, he just paraded in all these celebrities as his to vouch for his credibility. It sounds like this is almost like a popularity contest, like who has more rich, famous friends? Well, certainly Johnny Depp does in this case. Do you think that contributed to the jury verdict?
Thomas, if you're asking me, I think it did. He had his friends, people on his payroll, people that weren't, that came to Northern Virginia to testify in person on his behalf. He had a lot of witnesses. In terms of sheer number, he had more. In terms of how persuasive they were, he had more. You know, Amber Heard, if you think about it, who did she really have aside from her sister and aside from some paid experts show up in court to testify on her behalf? Again, I think the defense really underestimated what Heard needed to win, especially when they started running out of time and Depp brought in witness after witness to support their theory of the case that he'd never been abusive. And let's not forget, we had people from TMZ that came to show up to testify. You know, these people that volunteered to come to say that Amber Heard lied and that she leaked the video. We had the owner of Hicksville show up to testify. I mean, these were people that weren't even on the witness list, right? But because of what Amber Heard was saying, they were motivated. Maybe they wanted their 15 minutes of fame. That's what Heard's lawyers argued. But again, they showed up to Northern Virginia in person to testify on Depp's behalf. And I think that was very powerful.
And Professor Scartz, let me ask this question. So if the Depp versus Heard trial is a preview of what could happen in the future with the likes of Bill Cosby, Harvey Weinstein, et cetera, I mean, these are, again, very wealthy, resourceful men. I mean, is it impossible that they could also, if they are suing their accusers of defamation, they could parade in their rich, powerful friends and kind of bolster their credibility, while the victims, maybe they're not as advantageous?
I don't see why I wouldn't go down that path. One thing that keeps going through my mind as this conversation is going on, talking about a lack of evidence from the Heard side, and then a lot of reputed and well-heeled folks coming in on the Depp side. I think if and celebrities may be an exception to this, guaranteed, but I think if we all lived our lives and our days preparing for some theoretical litigation down the road, we would have more evidence, right? Like, had I known that I would have eventually have to defend a defamation suit, I would have been friendlier with my ex's staff or something of that nature, but people don't operate that way, right? So we just don't conduct ourselves as if we are preparing for litigation. And I would also say this conversation about popularity contests and whether they're good actors, I think courtrooms always have a performative aspect to them, right? I mean, everybody goes in and is on their best behavior, or at least is behaving as they perceive that they ought to. Sorry. Let me close this door. So I think that Nobody goes in and admits that they did it, right? Or admits that they lied, or they want to take their chances, roll their dice, see if they can put on a good performance. So, I think that the impact will be a broader spread, regardless of the celebrity nature. People are going to go in and say, I'm going to take my best shot. I can be an actor also, but courtrooms always have a performative element. So that doesn't surprise me much in these types of cases.
Okay, one more question and then we'll open it up to the audience. So if you want to ask a question to our panelists, feel free to raise your hand and we'll get to you next. So the outcome is, I think the way how the media kind of portrayed it, on balance, it's victory for Johnny Depp because he was awarded more in terms of the punitive damages. So I guess if someone could talk about the difference between the punitive damages and the actual damages from the jury verdict. Does anyone know?
Damages in a defamation matter are extremely difficult to get your hands around. How do you quantify the harm to somebody's reputation? How do you quantify repairing that? So, and again, this is a state by state issue. Defamation law, contrary to what a former president used to believe, is a matter of state law. So every state has its own formulation and its own definition of damages. So there are generally three types of damages that a plaintiff can be awarded. You can get compensatory damages, and you can get general damages, and then you can get punitive damages. But because of the First Amendment element involved in defamation cases, punitive damages tend to be rarely awarded. And many states will actually have a cap on punitive damages. And the judge in this case reduced the punitive damages, or the damages that are intended to punish that speaker or that publisher. So those were reduced to, I think, something like 350,000, which, I don't know, for lay people, that's a lot of money. For these two Hollywood celebrities, that's a days of a TV commercial or whatever they're hawking. So it's nothing to sneeze at, but compared to the millions of dollars that were awarded, that's kind of a small fraction of the overall damage award. But going back to the damages, and this played into some of the Depp witnesses who were trying to say that he lost these jobs because of this editorial, and that I don't think was ever fully connected. I don't think the evidence was able to pinpoint a specific date where this column was published, and then the next day he lost Pirates of the Caribbean 10 or whatever they're doing next. And that's a critical point with damages. And most lay people who get involved in a defamation case can usually point to the specific publication and a specific monetary loss. So, after this false statement was published about me, I lost the business deal. Or from a general damages standpoint, after this false statement was published about me, nobody wants to sit next to me in the cafeteria, or I'm excluded from my country club, or some other social stigmatization that is attached to this very specific false statement. And to be honest, I didn't see that at all anywhere in this case, which would then put the damages award kind of over the top compared to a fairly innocuous statement in a column.
Okay, so whenever the trial ends, the losing side always says we're going to appeal. So what do you think are the next steps now? Now that we have a jury verdict, I believe a judgment will be entered into, and what happens next? And if Amber Heard's side is appealing this case, on what basis can they appeal? Like, what are the reversible errors?
So based on what Elaine Bredehoff told the Today Show, she's going to argue that social media influence. You know, it was impossible for the jurors not to be on social media, particularly during that more than a week where the court was dark. And obviously, we've talked about how social media was overwhelmingly in Johnny Depp's favor. So that's sort of one argument that's going to be raised. And the second is some evidence that was excluded. The most important of which, of course, was that UK judgment that was the subject of a pretrial motion. They re-raised it in the middle of trial. They said Depp had opened the door. So they're going to argue that the fact that the judge excluded that UK judgment, that's reversible error. And there's two other categories of evidence that were excluded. There were some therapist notes between Amber Heard, the therapist notes related to Amber Heard dating back to 2012. The judge didn't let that in. Apparently, there's some text messages between Depp and his assistant that also weren't let in. I think those are going to be the two bases for appeal, but we'll see. The question is, though, under Virginia law, my understanding is that for the judgment to be stayed, Heard has to post the bond plus interest. Otherwise, she can file her appeal, but Johnny Depp can enforce the judgment. So we'll see if she has the funds to do so. I don't think she does.
And do you think this is one of those cases where Johnny Depp, who prevailed, is simply looking for a symbolic victory and not necessarily a monetary award?
Oh, absolutely. This case was never about getting money from his ex-wife. This is about him not being canceled and being hired by the major Hollywood studios again. And not only did he win, now he's probably the most sought after actor here in Hollywood. All those sponsors that dropped him, except Dior, I mean, they're going to be lining up to get Johnny Depp again because he's now one of the most popular men in the United States.
Well, we'll see how. Let me counter that. We'll see how much, how many movies he's getting offered after this, because regardless of him winning, there was still some pretty damaging revelations about this guy's behavior and his problems. So, a production company is going to have to get some pretty high level insurance to have this guy on set based on some of the evidence that was introduced at trial. But going back to the appellate issue, I can see them framing a constitutional deprivation issue as well. That this outlandish jury verdict flies in the face of the First Amendment and all the protections that were really kind of minimized during the trial. I can see them bringing some of that in on an appellate issue. But you're right about the posting the bond. I don't practice in Virginia, but I think we only have to go a little farther south to see how the posting of a bond for appeal can be a huge impediment. And I've got one word for you on that. That's Gawker. Remember Gawker versus Hulk Hogan?
Yeah.
There was a side defamation issue, but that was invasion of privacy. And I don't think that would have sustained a First Amendment appeal. But Florida had some outrageous bond requirement that a bankrupted Gawker couldn't post, and they ended up liquidating and selling off the assets. So we'll see what happens.
So, Professor Gutterman, if a constitutional issue is raised on appeal, so do you think there could be a scenario where they affirm the jury verdict, but they reduce the judgments because it has some kind of like a chilling effect? Do you think that's one possible outcome?
Yeah, reducing the damages down to something more reasonable might be an element. Also, there's a side issue that they might end up going into post-judgment settlement negotiations to reduce this to something that would basically cover the legal, that would basically be akin to covering the legal fees for an appeal, whatever it would cost for appeal. And again, if Johnny Depp's real motivation here was to clear his name, and not to punish his ex-wife or to chill future speech, then maybe they would go into some sort of settlement negotiations to avoid prolonging this. But we'll see.
And it sounds like what I'm hearing is if there's any kind of settlement negotiations post-verdict, it will be purely for PR reasons, because I think both parties want to kind of salvage their reputation and not drag this out. Is that a fair assessment?
Yeah, I mean, taking this to appeal would add hundreds, if not 1,000 hours of lawyer time. And that adds up. That's all billable time. So it might be cheaper for everybody to settle or to come up with some formula that's not in the $10 million range. But I don't know, but plaintiff's lawyers want that 33% of $10 million. That's not a bad payday. So we'll see what happens from that.
Okay, I know, Alina, you have your hand up. Before we get to your question, here's another point that I want to bring up, which is the hashtag Me Too movement started, I guess, about 5 years ago now. And back then, the mantra that came out of Me Too was basically believe all women. And now, with the outcome of this jury verdict, is it safe to say that we have kind of shifted in terms of the public discourse, believe all women, into believe those who are credible and you're innocent until proven guilty? Do you think that kind of burden in the public opinion has shifted?
I'm happy to take this, Thomas. I think there's a clear shift. I mean, now we're talking about men too. And, Depp, of course, we talked about how likable he was, but Amber Heard really is now the face of false accusations. I'm not saying that's right or justified. I do think that she was the victim of violence based on, the video and audio recordings, notwithstanding the verdict in this case. I do think obviously she had a role to play as well as maybe instigating some of this, but ultimately I think this case will have to be appealed for a few reasons. She can't discharge this debt in bankruptcy. Her back's against the wall. Any type of settlement, she's never really going to be able to, I think, act again. Any movie she's in will be boycotted by the masses. Already there's online petitions to get her removed from Aquaman 2. Her role has reportedly been reduced to 10 minutes. And the only reason I said I think Depp will be cast again is Hollywood studios in the business of making money, and they want to cast people who make money, and Amber Heard just isn't that person right now. So I think she does have a possible claim against her lawyers who helped advise her here in Los Angeles, who actually testified in the trial, that gave the green light that this op-ed wasn't defamatory. So she might have a malpractice claim. Look, and who knows, she has a relation with Elon Musk. Maybe someone can write a check for her. But ultimately, unless she can cover this judgment somehow, I think she's going to have to kind of take her chances on appeal, because she's got to clear her name. Just like Johnny Depp went the whole way, even though talking heads like me, we thought he didn't have a chance after 2020, frankly, but he had been canceled. He was out of work. So you got to go the whole way, try to clear your name. Now I think Amber Heard's in that position. That's why I think we're probably not going to see a settlement in this case, because her only chance, kind of like Bill Cosby, is to take it up on appeal and win and try to restore your name and act again.
Okay, thanks for that. Why don't we move on to the Q&A portion? So if you have any questions for our panelists, feel free to raise your hand and we will take turns addressing your questions. So we see a hand up from Alina. Hello.
Okay. Can you hear me okay?
Yes.
Thank you so much for organizing this panel, and all the speakers were brilliant. Something that Mr. Gutterman said that I thought was just a quick comment about that. It's so interesting because, yeah, I mean, Johnny Depp is about to enter another trial where he's a defendant in a case of assault. So this guy is clearly, has a temper problem. I'm a fan, or I was a huge fan of Johnny Depp as an actor. But I have a question for you, and I'm sorry if you addressed this earlier, and if you did, I missed it. Two quick questions. One is, can you please comment if you think the outcome of this trial may have been different had it not been televised? That's my first question. And actually, who decided that it should be televised? It was a good break from politics and COVID coverage, so I really appreciated 5 weeks of diversion from that. So that's my first question. And the second question is, the first week of the trial, Johnny Depp was allowed to go on and on and on, with like one sentence per hour, talking about his childhood and his life and his own, what his sister thought and what he thought. And I just couldn't believe that the judge, what did that have to do with anything? And again, so I'm a fan of Johnny Depp, so I thought it was fascinating. I thought it was just a fascinating psychological case. If I were, his friend or a therapist or just a fan. And then anytime Amber Heard started, she couldn't get 2 words out without like 15 objections when she started talking about her life, and the judge sustained all of them. And I'm just confused about how could Johnny Depp go on talking about his childhood for a week, and Amber Heard was objected to, every second word that came out of her mouth. So yeah, those are my 2 questions about, would it be different, do you think, if it had not been televised, and why was it televised? So that's the first question. And second question is, why did the judge allow this, difference in, their childhood history from one and not from the other? Thank you.
I could take some of that and then defer to co-counsel on this. I believe Johnny Depp made a motion, a pretrial motion to have this televised. And Court TV was a party to that as well. So I think that was part of it. Now, whether the trial influenced the jury, again, that's the jurors were told at every break not to pay any attention, not to pay attention to social media or read the news. But how do you, unless there's actual evidence that jurors disregarded that and logged on and watched the highlight reel on YouTube every night, that there's no proof of that. So yeah, and I might be a little rusty on my trial procedure, but I was wondering why Amber Heard's lawyers weren't objecting left and right on relevance grounds to some of these, old stories about Johnny Depp's childhood. Had we saw the constant objections by Camille Vasquez, and she was just objecting before the sentence was even finished. And I'm not sure some of those objections were well grounded, but it was enough to disrupt everything, and it caught counsel off guard, and they were not able to.
The judge sustained them forward. It's just the judge kept sustaining them. It was crazy.
Yeah, but co-counsel might have more to say on the objections as well.
Yeah, I can address the objections. Rottenborn, frankly, didn't do a good job objecting, and Elaine Redehoff didn't do a good job reframing her questions. If you don't object, the objection's waived. So this is kind of trial strategy. There are a lot of hearsay objections that were raised by Heard's lawyers, but they certainly didn't object to narrative and all sorts of other things that they should have objected on. Depp would go on and on and on. I don't know if it was a strategic strategy. Sometimes you kind of give the witness rope to hang himself, and maybe they thought, again, he's going to talk about drug use, and we want all this coming out, and this sort of antisocial behavior, just kind of strange behavior that Depp would go on and on about. But again, when it came to the objections, there was a clear winner in this case, and this was Amber Heard and her lawyers. Excuse me, Johnny Depp and her lawyers, his lawyers. Johnny Depp and his lawyers. The loser was Amber Heard and her lawyers.
And if I could just address the other part of Alina's question, I think, which was about them just kind of rambling on about Johnny Depp's background. I think that depends on whether if the question is being asked on direct or on cross. Cross, it's usually a more kind of like a kind of pointed questions, and the idea is to impeach the witness so that you don't look as favorable. Whereas on a direct examination, there's a lot more room to provide a narrative, sometimes even embellish. So I think that's what happened. I think the other aspect of the trial strategy is that I think there were time limitations on both sides, right? They were limited to a certain number of hours. I don't know what that is. I think it might be like 60 hours or something like that.
Yeah.
And from what I understand, Team Heard, they almost ran out of time because it was just poorly managed in terms of time management. And I think that's why towards the end, you saw them kind of rush through their witnesses, especially the expert witnesses who were providing their expert testimony on like substance abuse and etc. Okay. Oh, and the other question is this. I know Professor Gutterman had mentioned about possible tainting of the jurors by their use of social media. Do you know why there was no like gag order saying that the jurors cannot use social media or watch the news? Does anyone know what the answer to that is?
There was.
There was, okay.
Oh, yeah. I mean, every day before every break, before court adjourned for the night, the judge would tell them not to go on social media. I think the defense argument is it's impossible, especially during that break, where court is dark, for you not to pick up your phone, go on Twitter, go on TikTok, what people normally do. I think that's going to be the argument. I mean, but like, it's a civil case. You're not going to sequester the jurors, take their cell phones. I mean, that's such an imposition. It's not a capital case. I know people thought it was a very important case, but I just don't think that would be appropriate in a civil case.
Okay. Understood. All right, let's go to the next audience member. Paul, you have a question?
Yes. So I'm a little confused about all this attention on Me Too and the Believe Women and all that. We know that 40% of domestic violence victims are men. We know that men come forward far less than women do because of the stigma attached to being abused by women. We know that women, there's good evidence and good studies that show unreciprocated violence is done more by women at a 2-to-1 ratio. And we know there aren't any violence shelters for men. Even publicly funded ones are virtually all for women. Isn't this an absolute unequivocal win for men being able to come forward and finally be believed, where society is overwhelmingly biased to believe women in nearly every case? Isn't this absolutely a win for fairness, for the idea that anybody can be the victim of abuse? I find it hard to believe that legitimate female victims of domestic violence are going to be hesitant to come forward when you have a case where a woman is so, like Amber Heard, is so hard to believe based on everything she did at the trial. I don't see any downside societal to this at all. There were no comments about men being the victims of domestic abuse, and this case is about men being victims of domestic abuse. All the focus, and virtually everybody that I've heard from, seems to assume absolutely that Amber Heard was abused physically, despite the fact there's no evidence to that case. But I'd like somebody to comment on where is all the discussion about men in this equation. A man, we know because she admitted it, was hit. And it seems like it's invisible. Even in this discussion, it's invisible.
I can address some of that. So I think that I'm not sure about all of the numbers that you just gave us and where those come from. So if we had more time, I'd like to kind of talk about those. But those of us who work with victims know that shelters are providing services and shelter for men victims, separate and apart from the female victims. And yes, because the numbers are less, you don't have as much publicity, but I know where the male victims in my community can go to get shelter, and I know where they can go to get services. So I don't think that a lot of us who are working on the ground level know that those services are available. Part of what discourages some folks who identify as male from coming forward is the difficulty in admitting to their own community that they do not, they may not be perceived as being as manly, if you will, or machismo, or whatever the words might be. So I think there's some self-censoring due to community perceptions that are not directly related to the amount of services that are available. You know, my clinic represents people who identify as men, identify as women, identify as binary or neither, or services are widely available to all. So those of us who are doing the work, I think, are doing it at a different level than maybe what you see in the media. So if anything that I have said throughout this conversation that would lead you to believe that I'm working within a gender stereotype, we can possibly continue this discussion at another time, but in this case, we happen to have Amber Heard, who identifies as female, and Johnny Depp, who identifies as male. So that's the context in which I think we're having this conversation. So again, those of us who work on the ground level are offering services to victims, regardless of identification. And when media portrays it in equal numbers, then I think it'll be more visible what we're all doing.
You spoke mostly about shelters. California had to be sued by an association in Southern California in San Diego before they would allow men to apply to shelters. It's very recent. It was about 4 years ago. And I know the guy who did it. His name is Harry Couch in San Diego. Prior to that, and this goes back all the way, California shelters would not only not accept men under any conditions, this is publicly funded shelters, but they would not allow the teenage boys of abused women victims to stay at the shelter either. So there have been changes very, very recently, but I don't know what the situation is in other states. I find it hard to believe that other states still are starting to allow men in shelters, because when we published the Red Pill movie back in 2016, there wasn't one single shelter in the entire United States for men. So if things are changing, it's very recent. And again, I find it very hard to believe that there's anything close to the number of shelters necessary to meet the need. That being said, my main point was about the entire focus being on women being abused, when this is literally a case where not only a jury, but the entire country, the vast majority of the entire country, found Amber Heard not to be an abuser and Johnny Depp to have been physically abused.
I mean, I can address the prosecution part. I was a prosecutor in San Diego before, you know, I was here. So no, I agree with you. That's how Depp's lawyers closed their case, saying that Johnny Depp was the one who was abused. And that's something that the jury bought. My only point was, I think that just basically something happened here, and this was a mutually violent, toxic, violent relationship on both sides. But there's no question that the jury found that Johnny Depp was abused. And with respect to prosecution, you know, having been a prosecutor stateside and federal, just the practical reality is, Paul, and I don't want to hear it, it's just these are elected officials and they have a limited number of resources, and prosecuting female domestic violence perpetrators is not something that is a political winner. I'm not saying that's right. I'm not saying that's the way it should be, but I'm just telling you the reality. I haven't been on the inside when, you know, there's cases that are going to make headlines and get folks elected and reelected. That's where they're going to devote their resources, not prosecuting these types of cases that they should be prosecuted. Doesn't matter if it's the perpetrators are man or woman, in my opinion.
Just to clarify, Paul, I think you had mentioned that 40% of the perpetrators are women. Is that a national data? Because
the number that 40% of men are victims are the 40% of the victims of domestic abuse are men comes right out of Rain. That's
New
a very
Jersey,
well
I think it's
cited
47.
Yeah, it's
New
higher
Jer-
than 40.
Yeah,
Actually.
New Jersey is 47.
That
was a while ago.
There's a study from the Centers for Disease Control. It's called the National Intimate Partner and Sexual Violence Survey. And if you look at total physical violence on that one, it's basically 50-50. If you look at severe violence, you get something more like the 60-40 split.
okay.
And that's certainly not the national perception.
And believe it or not, I as an aside, I think lesbian domestic violence is like 60%. And I think homosexual is like low 60s, mid 60s. There are same-sex marriages or relationships are much higher.
What I've seen is that the rates among heterosexual versus homosexual relationships are roughly equal. It's slightly higher for LGBT than for heterosexual, but it's a relatively small difference.
Okay, well, I mean, I could give you some anecdotal examples because I practice law too here in New York, and my partner actually does a lot of family law. And usually the petitions for temporary order protection, it's filed by women in a domestic relationship. And I don't recall seeing like a 60-40 split, but again, that's just purely anecdotal. The percentage that I've seen are usually, it's overwhelming majority perpetrators male. But again, that's just my anecdotal example. And what I've noticed is that when it comes to, again, the domestic violence has, many different components. There's certain assaults and physical acts, but there's also like harassment, stalking. And right now we're in a digital age. So cyber stalking is a big one. And what I've noticed purely on anecdotal basis is that, the non-violent ones like the harassment and cyber stalking, that tends to be less men in terms of the perpetrators and more women. That's just what I've noticed. But again, the other thing we should talk about is what kind of protections should we have for victims of domestic violence? Because it seems like in most court systems now, it's very easy just to get a TRO. And sometimes the public perception is that, oh, there's a TRO, there must have been violence, but that's not always the case. So should the law be more protective towards the accusers, or should they kind of balance it out so that it's more, the burden of proof is higher for the accuser to get some kind of protection initially? What do you think about that? No, okay.
I mean, look, these are hard cases. Any intimate partner violence cases, as a former prosecutor, right? Oftentimes there aren't witnesses. There's not a lot of corroborating evidence. There's not contemporaneous reports, right? Prosecutors don't like to lose cases, and there are a lot of cases to choose from. So there's a reason why prosecutors who aren't willing to take the tough cases, and years ago, I used to be prosecuting police officers, for instance. They're rarely, if ever, prosecutor. We're seeing a little bit of a shift, but prosecutors don't like to take difficult cases. I'm not saying that's right. It's not the way it should be, but unless there's overwhelming evidence and they're going to get an easy conviction, it could be a layup or slam dunk or whatever sports analogy you want to use, they're not going to take the cases. And I think hopefully prosecutors start doing the right thing, start taking on righteous cases, regardless of the ease of winning. And I think hopefully we'll see a shift over time, but it's a challenge, to say the least.
Okay, let's go to the next audience. David, you have your hand up.
Yeah, thank you. So while we're on the topic of restraining order procedures, as I'm assuming those of you on the panel probably know, the Violence Against Women Act has provisions where accusers can have an attorney provided to them, federally funded, but the alleged perpetrator, the defendant, does not get an attorney in those proceedings. If charges were brought, they would be able to, the same way as any other criminal defendant. But as far as the restraining order goes, that it's one-sided in terms of who gets legal representation there. Was curious as to whether you had any thoughts on that, and whether any changes should be made there to balance the scales of justice a little bit there.
I have to say, David, I'm not familiar with the provision that provides attorneys. Is that could you be a little more specific on that?
My understanding is that there was a provision in the Violence Against Women Act that one of the things it provided funding for was covering attorneys for alleged victims, legal services for alleged victims, and that there was no similar provision for those who have been accused as there would be in a criminal trial.
Okay, so you're talking about just an expansion of available legal services.
Exactly.
in sort of the existing, within the existing legal services paradigm. Okay, that makes more sense. So that they would have to qualify financially for that based on LSC, federal poverty guideline standards and so on, is what I'm understanding you to be saying. So they're not available. It's not available to all petitioners. I'm interested in that. Love to have more information on that if that could be available. But I assume if it's just an expansion of the number of attorneys available in legal services corporation offices, civil legal aid offices, then applicants would have to qualify financially for those funds as well. So I'm not sure it's widespread. If it is, I'd love to hear more about it. But honestly, as someone who does restraining orders day in and day out, I would absolutely love if respondents had attorneys, because it'd be much easier to make it through the process, right? I would rather work together collaboratively with another attorney to reach the best solution for these families and these in these particular situations. So I would be all in favor of expanding. And I thought it was in New York City, where I'm obviously not familiar with it, but I thought in New York City, there was some discussion in legal services offices that if there was a criminal case moving along at the same time as the civil case, the public defender's offices were going to expand their contracts to allow them to also provide that representation in restraining orders. But I don't have the details or information on that. Some of you may have better information than me on that, but that is really the crux of it, is when a respondent is facing criminal charges stemming from the same sort of incidences, are they at a disadvantage if they don't have an attorney in the civil case, which often turns on the same factual basis. So again, I would actually welcome the expansion of those legal services to respondents. It would actually really, I think, help the process on both sides.
Yeah, and I think David's question kind of invokes a possible constitutional component too, because domestic violence matters are quasi-criminal. There's always a criminal component to it because certain predicate act is considered to be criminal, whether it's assault or harassment, etc. And in the criminal proceedings, you have the Sixth Amendment's protections that are attached to defendants, right? The right to counsel. So you could get public defender, but it seems like in the DV setting, it's just the reverse. It's the accuser that gets the right to have a counsel, and the respondent or the defendant does not. So maybe that's something else that the policymakers can look into, so that if both sides get counsel, as Professor Scartz had mentioned, then that would make sure that there's a right resolution instead of having an outcome that's not necessarily equitable. Okay, we do have another question. Rob, you're next.
Yeah, hi everybody. I'd just like to weigh in. Also, this is going to be anecdotal evidence and some personal experience, but I'm going to try to be as neutral as possible with it. Addressing the issue of the ease of getting protective orders, very easy to get. And I believe that it's gotten to the point, at least in family court, where that's used as a lever of abuse. And it's gotten to the point where you can go in ex parte under almost any circumstances and get a full protective order because the judges are afraid, and they're afraid if they don't grant it and something happens, then it's a big publicity issue. It's their job, all sorts of things blow up. So they're as easy to get as toilet paper, pre-pandemic, that is. And that's a problem in the system. It's a problem because people have adapted now to that new de facto state. And the first thing you do is you accuse of domestic violence and get a protective order. Now, I was involved in a situation with my son's mother where she did exactly that. And not only did she get the ex parte protective order, and it was never really addressed, at least not for a period of years until there was a hearing, she was able to have all sorts of incremental things granted to her based on that. Now, the issue of free counsel, if somebody claims they're a victim of domestic abuse, but not proven, not vetted, that also took place with my son's mom, and she has gotten free counsel now for the past 4 years to the tune of a couple of $100,000 that she would have had to pay out of pocket. Now she works for Cantor Fitzgerald, makes $150,000 plus a year, so she certainly doesn't qualify for this on financial means. But the fact that she had a false domestic violence accusation, she was able to basically ride that through this whole process. And it saps justice, it saps energy, it saps everything from the system, and it encourages bad behavior on anybody who sees how successful somebody can be with this strategy. So there needs to be reform. I know the reform is a huge Sisyphean obstacle because the courts won't reform. The legislature was the only one who could reform, and they're not politically motivated to do it because everybody's making a lot of money with the status quo. So I don't know what the solution is, but to fight it from the family court perspective, whatever, your hands are tied. There's very little you can do without spending a ton of money. If I was Johnny Depp and I had a couple of million to throw at the case, then probably I would prevail. But in the absence of that, you're at a great disadvantage. And really the child is the one who's the victim, who suffers. So
Well, thanks, Rob.
there does need to be something, as Christine said, about getting the parties together and working something out instead of just using the court system as a tool of abuse. And I'm trying to be as neutral as I can, but these are my observations. I also work for the court system now as a court-appointed special advocate, and I see this stuff every day. I work with abused and neglected children, and you don't see it much in the lower socioeconomic levels, but when people have money and they lawyer up, they use all of these tools and tricks to their advantage.
Rob, not an answer, but a comment. My wife is minors counsel in dependency court, which here represents foster kids. So CASA, I mean, you're doing God's work. So just credit to you.
Thank you. Yeah, it's wonderful work. Very rewarding. Thank you.
And Rob, just another 2 comments, I guess. One, I started out in law school many decades ago as a CASA volunteer as well. So again, close to my heart as well. But I would definitely agree with you that we need to reform it so that false allegations do not gain traction, because what that does is also take away from those who are making truthful allegations, in that the judiciary is tired, lawyers are tired, the system is tired. So sometimes the folks within the system lose the ability, law enforcement is tired of false accusations. They lose the ability to discern where there's true danger, I think. So I agree that there can be reforms made so that everybody benefits.
Absolutely. That's where it dilutes the justice. And it's unfortunate for the real victims then.
Okay, thanks, Bob, for sharing those personal experiences. We need to wrap it up here pretty soon. So before we do that, any other final thoughts that you'd like to share with us? Okay, well, I guess since we were talking about TROs, one interesting coincidence is that apparently when the jury verdict was handed down, that was 6 years to the day of when the original TRO was filed by Amber Heard. So again, was that a coincidence? Was that some other symbolic significance? I don't know, but I guess that's a good place to leave it. Thank you once again to our panelists, Professor Gutterman, Professor Scartz, and Mr. Rahmani. Thanks for your expertise, and we'll see you guys next time. Take care, guys.
Thank you.
Yeah.
Thanks, Thomas.